Start. Shri K. Shailendra, Learned Counsel for the applicant of review application, submitted that there is a mandatory provision of law that for deciding the appeal under section 100 CPC, it is a condition precedent to exercise power of the High Court to formulate superficial question of law and pass order accordingly, and second appeal cannot be decided merely on the equitable ground. He further submitted that in the present matter, no specific question of law was framed. No lower court record was summoned for consideration, and at the time of admission, this court had allowed the appeal after hearing the arguments of counsel for the parties. According to him, this was apparently an illegal procedure adopted by this court at the time of passing impugned judgment dated 13/5/2016, which is error apparent on the face of record. His submission was that although argument on points of judgment were placed by counsels for both the parties, but instead of framing of substantial question of law before passing the judgment, this court had erroneously passed the judgment of allowing the appeal. Therefore, said judgment should be set aside and matter should be reheard and redecided after framing substantial question of law. The submissions were opposed by learned counsel for the opposite parties, who submitted that in this matter, at the time of hearing of second appeal, all the questions on facts and law, including all the possible substantial question of law, were appreciated, and then, after due consideration on every point, judgment in question was passed. He contended that every fact in this matter was proved and admitted, and at the time of hearing of second appeal, concurrent finding of fact was there, which had earlier been given by trial court and was confirmed by first appellate court, and said finding of fact was being supported by respondent side. The judgment in second appeal was on the point of pure question of law, for which admitted facts were available before this court, which had considered them, discussed them, and judgment in question was passed after appreciating and deciding those points. He further submitted that after considering those points in said judgment, Supreme Court had affirmed the judgment, and it had specifically been observed that for said judgment of second appeal there is no reason to entertain SLP. His further alternative argument was that every probable substantial question of law was raised through argument of second appeal that was mentioned specifically by this court and was decided on merits without any factual or legal error. In such matter, there is no legal property to rehear the matter on technical ground for passing same judgment which is not erroneous on merits. So this review application should be rejected, as it is found that this judgment was passed after considering the admitted facts and admitted legal position. It is a fact that ordinary procedure is that before allowing